I think we're sorted.
So just give me one.
Grateful. So we go back to 1996, which was when the Act was passed. And since that time, there hasn't been any dispute about whether collateral warranties are included or not. That changed in light of a decision called Parkwood, which you will have seen. But even post-Parkwood, collateral warranties...
I'm sorry, we seem to be... The keyboard.
Oh, I see. Yeah, okay. I'll use this one. Okay, sorry.
No problem. Have not been routinely adjudicated. The decision of the majority in the Court of Appeal in this case obviously changes that. The key question for your Lord and Ladyships is deciding what these words in Section 104 of the statute mean. An agreement for the carrying out of construction operations. That's at page 501 of the bundle.
Sorry to interrupt so early on, but I thought there wasn't any longer any dispute about the meaning of Section 104, and the issue was whether this collateral warranty is an agreement for.
Well, the respondents say there isn't, my lady. We say there is, and you will see within the Court of Appeal judgment, we say Lord Justice Coulson in particular changed the wording of the statute. And rather than using for the carrying out of construction operations, he uses the word in relation to, in respect of. And we say that's an important change and a change that widens it. So there is, my lady, I believe, still an issue between us as to what the statute means. And why does this matter? It matters because if you're caught by the Act, there's then an automatic statutory right to adjudicate, which cannot be contracted out of. Now, the appellant respectfully submits that the majority of the Court of Appeal were wrong to take the broad and all-encompassing approach to the meaning of construction contract. We say that goes beyond the words in the statute and would take many agreements subject to the mandatory, would make many agreements subject to the mandatory provisions of the Act. We say that what those words mean, an agreement for the carrying out of construction operations, is an agreement, the purpose or object of which is the carrying out of construction operations, and by which one party undertakes a direct contractual obligation.
Can you say that more slowly, Ms. Day, so we can take it down?
Of course.
So, agreement, the purpose or object of which
is the carrying out of construction operations, and by which one party undertakes a direct contractual obligation to the other party to carry out the construction operations.
A direct contractual obligation to the other. Is that what you said?
To carry out the operations, yes. A direct contractual obligation to the other party. In contrast, an agreement by which the contractor merely warrants its performance of obligations owed to someone else is not a construction contract within the meaning of Section 104. And we say that is an important distinction that comes from the wording of the statute that was recognised by the compelling dissenting judgment of Lord Justice Stuart Smith in the Court of Appeal. There is then the second question, which does involve looking at the interpretation of the particular contract in this case between the parties. And you may have seen that the Court of Appeal did describe that as in the form of a standard collateral warranty. Parkwood, as we will see, had some unusual wording in it. And whether that falls within the scope of the statutory definition, as you decide it should be applied.
Although it's described as a standard warranty. In fact, it was a bespoke text which replaced the standard warranty that would have been attached to the standard form contract.
Yes. It had different wording to the standard form, correct, but the replacement wording was still in standard language. It's still very much a warranty, whereas, of course, when we look at Parkwood, we see the word undertakes coming into it rather than simply a warrant.
So your summary of your case, it reflects paragraph 13 of your written case.
It does, yes. It does. So we say under our agreement, we warranted performance of obligations owed to the employer. That's the crucial factor here. We're warranting performance of obligations owed to another person, the employer. The essential facts here are hopefully relatively simple. 2015 is the building contract for construction of a care home. Work commences 11th of May 2015. Practical completion takes place on the 10th of October.
The commencement of the work was before even the building contract had been entered into.
Correct. And then you have practical completion on the 10th of October 2016. In 2017, the building contract is novated to Topham, the freeholder. 2018, fire safety defects are discovered, and then remedial works carried out in 2019, 2020. The Abbey collateral warranty, it's called ACW in the submissions, was entered into in September, October 2020 with the lessee, Abbey. Obviously, that's a long time after the original works were completed, 4 years after PC and 8 months after the remedial works had been completed. And then there followed adjudications against my client in December 2020. The adjudicator found for Topham and Abbey in April 2021, and then Abbey sought to enforce the decision in the TCC. And that is how this issue has arisen. In response to the enforcement proceedings, we said that the ACW was not a construction contract within the meaning of Section 104, and the adjudicator lacked jurisdiction. The judge at first instance agreed, and obviously then the Court of Appeal have overturned that decision by a majority. As you will have seen, there is very little judicial authority on Section 104, and none, we say, on what is meant by an agreement for the carrying out of construction operations. Secondly, collateral warranties are widely used on construction projects. We see that set out in the judgment of Lord Justice Coulson at paragraph 36. They arise because of the House of Lords decision in Murphy and Brentwood, as a result of which defective building work is treated as pure economic loss and irrecoverable in tort. Collateral warranties obviously provide parties with an interest in the building, whether that's the building owner, a subsequent purchaser, a funder, or as in this case, a subsequent tenant, with a contractual right of action against the other party, often the main contractor, a subcontractor, or consultant. But we say these are not construction contracts, and the wording of the Act doesn't require them to be treated as a construction contract for the purpose of statutory adjudication. There is a measure of agreement between everybody, including in Lord Justice Coulson's judgment in the Court of Appeal. It's paragraph 34, if we could go to that a building contract and a collateral warranty are different things. So page 188 of your bundle. he refers to what's known as the classic definition of a building contract given by Lord Diplock in the Gilbert Ash case. And that is, quotes, an entire contract for the sale of goods and work and labour for a lump sum price payable by instalments as the goods are delivered and the work is done. And then that
you agree with that?
And we do agree with that. And as we will see, one of the very important purposes of adjudication was to ensure that there was timely payment on projects and that the progress of the work was not held up. But that reciprocal obligation by the employer to pay, we say, is an important feature of these that lies behind the introduction of adjudication, and hence we say informs the wording that's used in the 96 statute. And then that's to be contrasted with collateral warranty, described by Lord Drummond Young in Scottish Widows, and that is to provide a right of action to a person who is liable to suffer loss as a result of defective performance of a building contract or a contract for professional services in connection with a building contract, building project. So we do agree with that. The majority, both Lord Justice Coulson and Lord Justice Peter Jackson, both agreed that too, but they said it was irrelevant, effectively, to the issues that they had to decide. Why did they say it was irrelevant? Because they said the words "for the carrying out of construction operations" was to be given a broad meaning due to, and this is very important, the desirability of adjudication applying. And we will see that very, very strong policy driver behind the decision of the Court of Appeal in this case, and in particular the judgment of Lord Justice Coulson. What we say is the words of the statute mean what they say. They should not be construed more widely for perceived policy reasons. And we say what the judgment of the majority does in the Court of Appeal is to turn the words "an agreement for the carrying out of construction operations" into, quotes, "an agreement for or related to the carrying out of construction operations." And we say that was driven by this perception that adjudication was an extremely good way of resolving not only the construction contract, but all related contracts. And although this was a 2-to-1 majority decision in the Court of Appeal, Lord Justice Peter Jackson did have some reservations about the broadness of the approach that was being taken. And if we look at page 219 and paragraph 161 of his judgment, in this paragraph he is discussing the Parkwood agreement and considering whether that can be distinguished from the agreement in the present case. And obviously he disagreed on the facts of Lord Justice Stuart Smith. But he then says this on the fourth line: "I do, however, share the view he expresses at paragraph 82, so that's the view that Lord Justice Stuart Smith expresses, that one should be cautious about generalising. With diffidence, it seems to me that the last sentence of the commentary on Parkwood in paragraph 2.21 of Coulson on construction adjudication may be open to misinterpretation in saying that, from a broader perspective, if the underlying contract was a construction contract, it makes commercial common sense for any parasitic warranties to be treated in the same way." And he then says, I've acknowledged adjudication may well make commercial common sense, but the question of law is not whether warranties are parasitic, but what they contain.
But the majority don't decide the case along those lines, do they? They don't say a parasitic warranty is enough in itself.
They don't in those terms, but they do say that the words in the Act should bear a broad meaning. And in my submission, it changes. I take you to that just to show how strongly held the views are in terms of the direction of travel, if I can put it that way. And in my submission, that led the judges to fall into error in terms of how they construed the statute, the majority.
So on the broad meaning, Mr. Justice Aikenhead was wrong as well, was he, in Parkwood? Is that something he said?
Well, we can look at Parkwood. In my submission, he doesn't really base that on the Act. He in fact rejects a submission that the words for the carrying out of the construction operations should be construed to mean in respect of. He expressly rejects that, and he rejects a submission that if collateral warranties are not excluded from the Act, they were intended to be included. Because, of course, as we know, bonds and insurance contracts and various other things, 2 years after it was brought into effect, were then excluded. So we can look at Parkwood, but in my submission, Parkwood is very much based only on the wording of that particular agreement. And Mr. Justice Aikenhead goes out of his way to not be setting down any broader proposition than that. So it does turn on the facts in his submission. Whereas when we come to the judgment of Lord Justice Coulson, he, in my submission, is making comments about how the statute is to be implied. But we submit, with the greatest of respect, are not the right approach to the statute.
As I read Lord Justice Peter Jackson's judgment, he did not go along with that way of interpreting Section 104. There's the reference you've given, but there's also paragraphs 147 and 148 and 149, where he says you just approach this as an issue of statutory construction in the usual way.
That's correct. He doesn't explicitly say he disagrees with Lord Justice Coulson, but I agree with you. Although it's a majority decision on the question of statutory interpretation, in my submission, actually, Lord Justice Stuart Smith and Lord Justice Peter Jackson are aligned on that and are concerned that the breadth is being taken too wide.
Yeah, that actually is how I read the two judgments, or the three judgments too.
Yes, but in my submission, Lord Justice Coulson, whose judgment is taken as the lead judgment, or as setting out what the majority's decision stands for, very clearly
well, I'm not sure. I don't think you can say that. I think you have to, in order to discern the majority reasoning, you have to read the two judgments together, and you have a majority in the decision, but not necessarily in the precise route whereby that decision is reached.
I understand that. What we would be keen for this court to do is to correct what is said in the judgment of Lord Justice Coulson. For example, I will go to it now. At 39 and 40 of his decision, and in particular 40, he does talk about Section 104.
Page?
It's page 189.
Thank you.
It really starts at 38, where he says that these words should be construed to mean what they say. And at 38, he is saying that Mr. De Gregorio, who argued the case below, shouldn't have used the word under which. He disagrees with that. And he also rejects the synonym to carry out construction operations. He then says in 39, as a matter of language, it seems to me that an agreement for the carrying out is broader than the interpretation given. It's not confined to a traditional building contract. And then he says, given the words, a broader meaning is how it's been approached by courts in the past. Now, he then quotes back 23 and 24, if we turn back to 184. The first case is Gillies and Ramsey, which is a contract administrator, and the second case, and that is covered by the adjudication regime. And then the second case, Fencegate and James R. Knowles, that is not covered, a claim for fees for work done in an arbitration by construction claims companies. Neither of these claims, neither of these decisions in my submission assist with the issue you have to decide here. And then 24 obviously deals with Parkwood, and I'm going to go back to what Parkwood said. But then if we turn back to page 189, he says it's a broader construction. He says at paragraph 40 that he then relies on section 104.5, which is the section concerned with hybrid contracts. I will come back to that because I'd like to look at the Act. But we say that, in fact, it supports our position in that relates to hybrid contracts and uses the word in relation to construction operations. And then he sets out at paragraph 41 that the 1996 Act was intended to improve the payment regime, and then he sets out at the end that what happened in the present case was what the 96 Act envisaged, the same underlying dispute about the same defective work arising under two different contracts but decided in parallel by the same adjudicator. In my judgment, that statutory purpose is a relevant factor in construing section 104.1. And then the nub of what...
You could have the same dispute arising even under something that was very clearly just a warranty.
Correct.
Which wouldn't be. So you wouldn't, even this broad construction of the statute would not always result in a factual dispute about a defect always being heard by an adjudicator.
Well, that's correct, and therefore we say that isn't a justification for it. It's rather circular. What, in my submission, his primary driver is set out in paragraph 58, because he doesn't, within these paragraphs, actually say what the statute means, but he does at paragraph 58, and that's at page 193 of the bundle. And at 58A, he reiterates 104, broad expression, regularly construed as such, see in particular Parkwood. D, there's no reason to limit the words of section 104 to refer only to the primary building contract in any situation. And then E, a collateral warranty, and this is the crucial paragraph, may therefore be capable of being a construction contract for the purpose of section 104. What may be critical is whether the warranty is in respect of the ongoing carrying out of construction operations on the one hand, or is in respect of a past and static state of affairs on the other. And this is his distinction that we say is a very unsatisfactory distinction that one is left with after this case, that whether you're covered by the Act depends on whether you warrant a past state of affairs or there is some warranty in relation to an ongoing state of affairs. But the importance of the wording here are the use of the words in respect of, which in my submission show that when construing the words of the statute, an agreement for the carrying out of construction operations, there is a widening of it in terms of what it means.
Because you say in respect of is broader than for.
Absolutely. Absolutely. And I know that you have had various dictionaries cited to you, but in my submission, that's an obvious point.
But as regards his statement earlier that it goes more broadly than traditional construction contracts, presumably he's referring back there to the Gilbert Ash definition. Do you say that that is too wide? Do you say it's limited to traditional building contracts of that kind?
Well, I think I put it in a different way. I would say what it doesn't cover, and it doesn't cover where you have a promise to somebody to carry out an obligation to someone else, the employer, to build something.
So what's your position on whether it covers collateral warranties generally, or do you say one can't generalise?
Well, one obviously should look to substance rather than form, and a bit like the without prejudice rule, you can't stick the word collateral warranty on the top of an agreement and assume, therefore, I'm not subject to the automatic regime. But if the substance of that document consists of a promise to perform a contract owed to another person, in effect the employer, then that is not a construction contract within the meaning of the Act. And that's one of the reasons why Parkwood, in my submission on its particular facts, although it was called a collateral warranty, it obviously contained an undertaking to carry out the works themselves. So it wasn't just
But it was
warranty.
still an undertaking to carry the works out contained in the building contract, the separate building contract.
Correct.
And I can understand the difference between a warranty
Yes.
and a primary obligation.
Yes.
If it's a warranty that somebody else will do something, or if it's a warranty that something has happened in the past. But if in relation to something that in the building contract is still executory, I find it slightly difficult to think of any real difference in substance between a promise that you'll do it, or a warranty that you'll do it, or an undertaking that you'll do it. Because in substance, in each case, you're saying to somebody else with contractual liability, I will do it.
Yeah, I mean, in some ways, that's a debate about the wording of Parkwood. Obviously, in terms of our wording.
It's really more of a debate about, I mean, if you've got undertaking as well, you can construe it in a certain way. If you haven't got undertaking, as here,
Yes.
nonetheless, the question is, what's the difference between promising you will do it and warranting that you'll do it?
Well, the difference is important in this context because, as you will be aware, adjudication, and we will look at that, one of the primary purposes of adjudication was to ensure that people got paid.
Yes.
And a building contract is a reciprocal arrangement. So, for example, I have to perform as the contractor, but then I'm also entitled to be paid.
I can quite see that difference.
Yeah.
I'm just looking at the point about whether there's a difference between a warranty that you will do something and a promise that you will do something, regardless who's paying for it.
Well, I don't think there's a difference if what you're promising is to carry out your obligations to someone else under a different contract.
And as I understand it, you're saying that that is not a construction contract within the meaning of 104.
Correct.
So it doesn't matter whether the word undertaking is used, or
That's
promise,
correct.
or warrant.
That's correct, yes.
Yes, I see.
But your concern is that if one uses the term, it's a contract in relation to construction operations, that might cover what we've been describing as just an ordinary guarantee type warranty, if I can think of it like that.
Yes, that's correct.
And therefore absorbs both sides of the distinction that we've been describing.
Yes, no, absolutely. Because the word for, obviously, we say denotes the purpose of it, it denotes an employment connotation, that you are actually employing the person who is then carrying out the work. And that makes sense within the context of adjudication, because one of the things that it was intended to do was to correct the terrible state of affairs that had arisen whereby building projects couldn't be completed, and it's a reciprocal arrangement. And certainly this collateral warranty, we say, is very, very far from what the drafters of that Act were intending to include within the meaning of that.
But when you were taking us to Lord Justice Peter Jackson's judgment, were you saying that he did not go as far as Lord Justice Coulson, and so would not extend it to cover true guarantee-type warranties, even though, because they are in relation to a construction operation, even if they're not for the carrying out of works, but so that was...
Yes, I mean, the nub of what he decides is probably at 216. In terms of the statute, it's paragraphs 152 and 153 at page 216. And he says at 152, the word "for" requires the purpose or object of the agreement must be the carrying out of construction operations. It is concerned with the performance of construction operations and not their consequences. It is not enough that the agreement concerns the quality of the work.
I see. And you contrast that with Lord Justice Coulson's expansion of the word "for" to "in relation to."
Yes, I contrast that with paragraph 58, and in particular E.
So what do you say about 152?
Well, 152, in a sense, leaves certain questions unanswered. We say it doesn't go far enough. We obviously say that the member of the Court of Appeal whose judgment you can seek assistance from, and his dissenting judgment has been described in the industry as a powerful dissenting judgment, it is the judgment of Lord Justice Stuart Smith, which we have set out extensively in writing.
Before we go there, I'm really sorry to interrupt. It doesn't go far enough, but you do agree with what it says at 152. You add the question of direct obligations to it, but otherwise you do agree with it, don't you? That's what you said.
Yes. I mean, I'm just looking at it compared to the end of paragraph 93, which is Lord Justice. Construction contract is an agreement, the purpose or object of which is the carrying out of construction operations, or arranging for them to be carried out by others, or providing labour for carrying them out. But yes, I think what is said at 152 requires the purpose of the object must be the carrying out of construction operations. Yes, those paragraphs say the same thing. On that particular point, obviously on the facts, we don't agree with the conclusions that he reached. But the direct obligation point is an important qualification, because when we look at what Lord Justice Coulson says at page 187, paragraphs 30 and 31, this is where he accepts that if you have a simple promise or guarantee in respect of a past state of affairs, that may not be a contract for the carrying out of construction operations. So he says if you had something along these words, we completed these work 2 years ago, we warrant that they were completed in all respects in accordance with the building regulations, he says that doesn't recognise or regulate the ongoing carrying out of any future work. It may therefore not be a contract for the carrying out of construction operations. It is more akin to a product guarantee. And then at 31, he says, on the other hand, a warranty that the contractor was carrying out or will continue to carry out construction operations may well be a contract for the carrying out of construction operations in accordance with Section 104. That is because, unlike a product guarantee, it's a promise which regulates, at least in part, the ongoing carrying out of the construction operations. And that is the paragraph that we say is wrong, because there is no direct obligation. And we also say that that would be, with the greatest of respect, somewhat unprincipled and is likely to lead to a great deal of confusion, which is not a good thing in terms of what is within and what is without the Act. Whereas the beauty of the approach taken by Lord Justice Stuart Smith is it's very simple, it's very clear, and it's true to the principles. If you can look at page 204, paragraph 109.
Sorry, paragraph?
109.
Thank you.
And it's just before, it's just about halfway down, slightly less than halfway down. A liability for breach of a warranty is conceptually different from a liability for breach of direct obligations owed in respect of the underlying state of affairs. It rests simply upon the fact that the warranting person's promise is found to be broken. So we say that it is a different thing in this case. And Lord Justice Stuart Smith, earlier in his judgment, sets out, again in relation to the statute, a compelling analysis of how Section 104 operates. So if we could go back, please, to page 200. Paragraph 90, he agrees that the word for is very important. Paragraph 91, he says the word for has a clear and well understood normal meaning, which is to denote the purpose or object of the agreement. Typically, an agreement for something means that someone agrees to achieve that thing or to bring it to fruition. Although normal meaning is not beholden to dictionaries, he then refers to the OED of purpose, result, or destination. And then this last sentence, it carries with it the implication that a party to a contract for the carrying out of construction operations, typically the contractor, undertakes the direct contractual obligations to the other party, typically the employer, to carry out the construction operations.
Now, do you agree or disagree with that?
I agree with that.
But what about when he says the other party, typically the employer? Because that connotes it need not be the employer. It could be someone else.
Correct. It could be, but in this case, a collateral warranty, a true collateral warranty, will not be that, because you will be warranting performance.
I understand that.
Yeah.
I just in terms of the scope, because I think you're primarily on Section 104 now, rather than on the construction of the contract in question here. I may have noted it down wrong, and this is the source of my confusion, because I thought at one point you submitted that a promise by A to B to perform, I think I added the A and the B incidentally, a promise by A to B to perform a building contract which A has made with C is not capable of being a construction contract within Section 104. But I'm not sure that can actually lie with that last sentence of paragraph 91.
Apologies. Here, he's setting out what will come within the Act.
Yes.
Yes.
That's right. But do you, I mean, I'm focusing very much on the words typically the employer, because it seems to me that suggests that it might be someone other than the employer. For example, a beneficiary of, well, for example, a tenant of the building. And so that's why I'm focusing on that, just to understand precisely what your submission is on 104.
Well, the direct contractual obligation, I mean, typically it will be an employer.
Typically, yes. But does that mean always or just normally?
Well, you have to combine that with what follows in 92, where they talk about an entire contract for the sale of goods and work for a lump sum price. So you have to have that reciprocality. So someone's performing work and they're being paid for it by the same person. And that then is a primary obligation to provide the goods, work and labour for the carrying out of work in return for the payment.
Yeah.
So have we got to hear that you press the distinction between an agreement where there is a direct contractual obligation contained in the warranty to Abbey, the beneficiary, contrasting with where there's only a direct obligation to carry out the construction operations to typically the employer?
Yes.
And then, and if all that is in the collateral warranty is akin to a product guarantee, then it's not a construction contract. And your concern is that the breadth of the wording adopted by Lord Justice Coulson, particularly in 58E, is he seems to say both those kinds of contracts are construction contracts within the meaning of Section 104.
Well, I think he says the pure product guarantee situation would not be.
Right. So
he does say that wouldn't be. Of course, it's quite complicated because of the doctrine of retrospectivity. Yes. So, of course, you can have something that's actually been finished, and then it depends on the words that are used. I mean, my submission, in a way, is a very simple one. And we say something that the industry needs to have guidance, because in my submission, this is a trap for the unwary in terms of how you precisely word your collateral warranty. It would be much better to apply the words of the statute. I'd like to go next to the statute just to look at it. The entire thrust of this statute was that the statutory adjudication regime was to apply to something that involved action, so carrying out, doing something. It was never intended, in my submission, to cover the situation that we have here. And that is for good reason, because that wasn't what the drafters of the Act were aiming at. That wasn't the evil, and that was then present. So we say it's much simpler to have this as a direct obligation test. The word for is very simple and straightforward, and for the reasons elaborated by Lord Justice Stuart Smith, we say that is a much clearer, better test. It's also the only test that is true to the language of the statute.
But you also accept, I understand, that the reason that the first instance judge gave, which is, well, this can't be for carrying out construction operations because they'd already been done, that's not a good reason. You do have to look at the wording of the contract in a way divorced from the actual situation on the ground, if I can.
Yes, we would say you look at the type of obligation.
Because the odd thing is when you took us to that paragraphs 30 and 31 of Lord Justice Coulson's judgment, where he contrasts, we completed these works 2 years ago and we warrant they were completed in all respects, with something that doesn't say that, it just says it just warrants the construction of the works. What we've got here is a mismatch between the factual position and the wording of the contract, because looking at the wording of the contract, you would think the work was still going on, whereas we know in fact it wasn't.
Correct.
But I don't think you rely on that as an indicator as to the meaning of the wording of the contract even.
No, I mean, we've thought about this because obviously the statute also says that you have a right to adjudicate at any time. And what does that mean? So in a sense, the temporal question shouldn't be driving whether something is covered by the Act or not. But our position is that you do away with all these difficulties if you actually say that a collateral warranty just isn't covered by the wording of the statute, because the wording of the statute requires a direct obligation, an obligation to perform and then a reciprocal obligation to be paid. It's to do with the employment, the actual carrying out of the work.
Well, that means that you are restricting the meaning of construction contract to the contractor and the employer, aren't you?
Well, it depends whether you could, I suppose, have an agreement. No. So, for example, you could have the contract novated. So top
No, never mind about that's an added complication. But I'm just supposing that without any question at all, the collateral warranty in this case used sort of Parkwood type language. The contractor undertakes to perform the principal contract in accordance with its terms, and that's given in favour of Abbey Healthcare. Do you say that that is incapable of being a construction contract as defined?
Sorry, if it says...
It says the contractor undertakes to perform the principal contract.
Yes,
to build the care home in accordance with the terms of that contract. So it's a direct obligation. It's drafted as a direct obligation by the contractor in favour of Abbey Healthcare, the prospective tenant. The question that I would like to understand is whether that passes your direct obligation test. And if not, why not?
I think that my primary position would be that it doesn't, because if you look at it's not for the carrying out of, but obviously that is, in a sense, Parkwood. Parkwood, obviously, there was a direct duty of care as well that was imposed. But undertaking to do, I would say, is different from a warranty.
Well, I understand that, but that's when we come on to contractual interpretation. But at the moment, we're on statutory interpretation. So, I mean, I think your sort of position I'm getting is that the example I gave you, you'd prefer not to accept it was a construction contract, but you don't seem to be pressing that very hard.
I think as a purist, I find it hard to see. If you look at it as a pure direct obligation, it would depend whether that person had the right to enforce that as not a claim for damages, which obviously you have under a warranty, but a claim to actually perform it.
But yes, I mean, whether you just have damages or whether you have a remedy of specific performance, if otherwise available, is a question to be asked once you've decided what the promise is. It doesn't help you decide what the promise is.
It would be quite surprising if the outcome of this question under this Act turned upon whether you could get specific performance or not in a construction area where generally
I agree.
For well-established reasons, specific performance is not available.
Yes, I agree with that. But I do say that the beauty of saying it's a direct obligation is that is entirely in accordance with what this Act was intended to achieve. And it's simple, it's straightforward, and it does away with the some of the distinctions that we see that have beset collateral warranties and the complication for something that was intended to be introduced to simplify the position post-Murphy and Brentwood. It, in fact, has led to a lot of disputes, not about this point, but about the retrospective effects, what they mean. But certainly in my submission, one can and should take into consideration that although it might be seen as desirable to have disputes dealt with in one forum, that's not the way adjudication works. It's not. You have to fit yourself within the dispute. You have to fit yourself within the statutory regime. You can't bring parties into the same adjudication. So we say that one looks at the statute and one looks at the words used, and perhaps we should go to the statute. It's page 501, just to have a look. So 104.1, an agreement, a construction contract means an agreement for any of the following. So 1, the carrying out of construction operations. 2, arranging for the carrying out of construction operations by others, whether under subcontract or otherwise. C, providing his own labour for the carrying out of construction operations. And when you view it in that context, you will see that Parliament has provided, these are all active performance obligations, carrying, arranging, providing. They are not intended to cover what we have in this case. And then at 104.2, we see that a construction contract includes an agreement to do architectural design or surveying work, or B, to provide advice on building, engineering, interior, etc. So you will see here it goes slightly beyond an employer building contract type of relationship to cover professionals. But again, these are all performative obligations to do, to provide, and all of those things. And then you see these words, in relation to construction operations. Now, there's been an awful lot of cases about what construction operations means. Fortunately, that doesn't need to trouble you in this case, because the parties are agreed these were construction operations. But I compare and contrast the use of the word in relation to when Parliament is referring to construction operations as compared to an agreement for. At the start of 104.1, we do not see the words an agreement in relation to. It's an agreement with a person for. And then any of these active words, carrying, arranging, providing, doing, providing, advice. And then at 104.5, and this was a section relied on by Lord Justice Coulson to say it has a wide meaning.
But not by Lord Justice Peter Jackson.
No, not. And I think it's relied on by the respondents in this case. We say that this actually helps us because when you read 104.5, it says where an agreement relates to, so again, this wider wording, where it relates to construction operations and other matters, so that's what's known as hybrid contracts, which might cover construction, but also other things not covered by the Act. This part applies to it only so far as it relates to construction operations. That doesn't have anything to do with what the word construction contract means. So it doesn't assist you with construing the provision that you are asked to.
But it could have said this part applies to it only so far as it is for any of the following in any of those listed in 1A, B, and C.
Well, no,
but
because
I think the point he's making is it doesn't say that, it says so far as it relates to, but that's obviously what it means, and so it must be using as it relates to as meaning the same as...
Well, the whole point, it's the second sentence that matters here, isn't it? I mean,
Yes.
there's no magic in the words relates to. The second sentence tells us what relates to means. It simply takes you back to contracts for the various things in 1 and 2.
Yeah.
So I mean, with all due respect to Lord Justice Coulson, it seems to me to be a point with no substance at all.
Yeah. We agree with that. We say this doesn't assist because it's not telling you what a construction contract is.
I mean, it tells you in the second sentence. It just takes you back to 1 and 2. It was just a drafting technique for what would otherwise be a rather convoluted provision.
So in my submission, when you look at the statute and you look at the words "an agreement for the carrying out of construction operations" in this context, it becomes very clear what Parliament was intending here, which is a direct performative obligation. It doesn't cover the types of contracts, the types of obligations that are present in this case.
But when you say that, you're not relying on, you're not saying that the reason why this was not a performative obligation was because all the performing had already been done long before.
No.
You're just looking at the wording of the contract and saying there's no direct obligation. Can we just be absolutely clear about that?
That's correct.
And the heart of your submission, as I understand it, is that it's not a direct performance obligation if it's a promise to perform a contractual obligation owed to somebody else.
That's correct. It's correct. And that, yeah. I say conceptually those are different. It's a very simple, straightforward test. It means that everybody knows. Of course, it's always open to parties to add in adjudication. So it would always be open to people to put an adjudication provision in a collateral warranty. And of course, there's always court. But it's possible for it to be structured in that way. Then the parties have a choice. What we say is highly unsatisfactory is where the industry is left after this decision, because one will start looking at clever ways of wording collateral warranties to try and bring them inside or outside the Act. And these fulfill a very important purpose. You don't want to discourage them being provided or it being clear what they mean.
Can I just ask you, you mentioned a little earlier that there had been I don't know if it was a statutory instrument a couple of years after the Act was passed. Do we have that statutory instrument?
No, but it's described in Parkwood, so maybe should we go to Parkwood now?
Well,
I'm just trying to go through in some logical order, but Parkwood is at page 866 of your bundle. Yes. Okay, yes. And if we go first of all to 867, you can see, this is obviously the commentary that precedes the actual decision, but I take you to it just to show you that Parkwood came as a huge surprise to everybody, because before this, it hadn't been considered in the industry that collateral warranties were included within the Act. And that was despite it having been in force for a very long period of time. So the commentary records no previously reported judgment considering this issue. And then if you look halfway down the second column, Mr. Justice Aikenhead approached the question of whether or not collateral warranties fell within the Act by considering the words used in the particular agreement before him. So we will see he doesn't go into what the Act means in the way that the Court of Appeal did in this case. And then at the bottom of that page, you see it being said that one will just need to look at the wording of what the agreement says.
But the advice that you say the Court of Appeal has left the industry with was there from Parkwood.
Is therefore,
Look
sorry.
at the wording of the collateral warranty in each case, but you're not challenging Parkwood.
Well, in a sense, I don't need to, because Parkwood is on its facts. I'm not trying to say on the facts of that particular agreement. There's a different decision that should be made. Because we will see why that was, but that's all Parkwood said. It didn't actually say what the Act meant in the way that simply this case in the Court of Appeal.
But on the key distinction which you rely upon, namely what stops it being for construction works,
Yes.
is that it's a promise to carry out a contractual obligation owed to someone else.
Yes.
And on the face of it, that would apply to Parkwood, wouldn't it? There was a prior contract to carry out the works. And although, and all the promisor did in the collateral warranty was, quotes, promise, undertake and warrant to do just that.
Yes, page 871.
So why doesn't that fall foul of your critical analytical tool, which on the face of it, it's a very clear tool. If it's an existing contractual obligation and you contract again with someone else, then you ask, are you contracting afresh with someone else, or are you simply contracting to perform the existing contractual obligation?
Yes, yes.
And in Parkwood, never mind the torrential language of obligation, that's all they contracted to do.
Yes, I mean, I think I would have to accept that on that logic, then potentially Parkwood it isn't correct, but it's not formed part of this appeal to seek to challenge Parkwood on the facts. And indeed, you will see that in the Court of Appeal, Lord Justice Stuart Smith felt that the word undertaking did connote something different. But
yes, I don't think he actually, I forget where he said it, but I think somewhere he indicates that he would not agree with the strictest form of your direct obligation test.
Yes.
And he decided it on a matter of construction of the warranty in this case.
Yes, yes. But we say this court has the opportunity to set out clear guidance, and that this court should take that. The page 871 is obviously the facts in Parkwood, and the two provisions, obviously, that the contractor there warranted, acknowledged, and undertakes that. So those are the different words, and then two, and this may is a point of difference. It was accepted in Parkwood that the contractor actually owed a duty of care to the beneficiary in the carrying out of its duties and responsibilities in respect of the works. So there was a direct duty, in a sense, being taken on under Parkwood.
That's directly to get around Murphy and Brentwood.
Well, it's not found.
Contractual duty of care where the law of tort doesn't impose one.
Yes, although interestingly, that isn't to be found in lots of other collateral warranties. In Parkwood, it was specifically put in there in those terms.
Yeah.
Do you say there's a material distinction between clause 1.1 in Parkwood and clause 4.1a in this case?
And B.
Yes, I do, because 4.1a in this case uses the word warrants. So we don't have any undertaking to carry out the works.
It simply goes back to your undertaking.
Yes.
Yes.
Because
You could, I suppose, if you're looking at page 871, the torrential phrase warrants, acknowledges and undertakes that it has carried out and shall carry out and complete. You could say, I suppose, that warrants and acknowledges relates to the past and undertakes relates to the future.
Yes.
Just as a matter of language.
Yes, no, you could say that.
I mean, there is a direct duty of care in the warranty, in this case in 4.1b.
Yeah. Yeah. It's the word undertakes has always been the reason that this case has been distinguished, and in my submission it does carry with it a qualitative difference to the wording that you are concerned with.
But how does it work? I mean, only for the consideration of £1, they're promising to. You'll say they're undertaking to carry out all that building work.
Yes.
Which they're already promising to somebody else to carry out as well, presumably for much more than £1.
Yes.
And if there's then the employer, who's actually paying for the work, decides actually they want the building over here instead of over there, and there's a variation of the building contract, somehow that must track across
Correct.
whatever building obligations there are under this contract, because you can't have them.
You don't get any greater rights than you had under the building contract. So when we look at the wording of the collateral warranty in this case, it says you can't have any greater rights.
Does that mean the building contract in its then form, or as it might be varied thereafter between its original parties?
I think it must be as it is at all times. So even if it's varied, you can't ever have any greater rights than exist under
greater or lesser. They might be different. I mean, it could be that, let's say, the contractor says, actually, I want you to build the house 2 stories rather than 3 stories. There would still be an obligation that would presumably affect the obligation to the third party. Now that obligation must be only to build 2 stories, even though that's less than they was originally contracted for. You can't have them bound to somebody else still to build the 3-story house.
No. So it tracks and it follows the building contract, whether that's varied or changed.
But the beneficiary here can't themselves change the nature of the building, of the carrying out,
Correct,
of the construction operation. So Abbey can't say you only need to do 2 stories rather than 3 stories.
correct. And that would be a reason why when you look at the wording of the Act, it doesn't fall naturally within that wording, because it's not carrying out, arranging, providing, directing, doing the work. It just doesn't naturally fall within it. Of course, primarily these warranties come into effect when there, for example, alleged defects in the building, and here the lessee of the building wants to have a direct right for that to be dealt with. So they could then bring a claim in court to have those dealt with if under the building contract they haven't been dealt with, because of course it should be dealt with within that context, but they retain the right, which they wouldn't have absent the collateral warranty, to bring a direct claim in that sense against the contractor.
And the warranty tracks the main contract if, for example, it's terminated by an accepted repudiation, presumably.
Yes.
Yeah.
Yes. But the beneficiary can't affect what's happening under the building contract.
No.
That remains separate.
So if the original parties to the building contract say, oh, well, let's forget it, let's just call it a day, the beneficiary of the warranty is equally affected.
Well, in terms of any work done to date, but yes, it would have to be in the context of why the work had stopped. So if it had stopped prematurely, you couldn't complain there was a defect if the contract hadn't been allowed to complete it.
And if the contractor does a deal with the employer under the building contract, settling for a mess of pottage or its potential liabilities for defects and so forth going forward, is the beneficiary of the warranty similarly affected?
Well, it depends on what loss has been suffered, so what damages could be claimed. The lessee might say there was a defect in the building that hadn't been remedied. In that situation, the employer and the beneficiary under the collateral warranty might have separate claims. So if you're a lessee of a building and you have a business and you have to vacate it, you're going to have a different claim to the employer.
But the right of the warranty holder can't be affected by a decision of the employer not to bother suing, because that's the absolute reason why
Correct.
they want to have the
Correct.
warranty, because
you
they're
could
now living in the building, the employer is long gone, and doesn't have the same interest in making sure the building is safe as the person who's now running their business there.
Yes, so you can't have double recovery.
No.
So say the employer gets the money to fix the defects and doesn't do it, then there would be an issue. But you can't have double recovery, but the beneficiary of the collateral warranty may have additional rights.
But they may also have rights against the landlord.
Correct. And obviously that dispute, for example, a landlord-lessee dispute isn't going to be an adjudication. So when one looks at the policy reasons for this, there are arguments both ways, and I want to come on just to have a look at those. But if we can just finish Parkwood and then have a look at that. So Parkwood at paragraphs 20 and 21, it's page 873 of your bundle. Paragraph 20, he sets out that there's no authority on the proposition to the extent to which a collateral warranty is a construction contract. And then he cites the wording of the statute. He says that those are unambiguous. And then at 21, he actually cites at the bottom, the second half of 21, Mr. Justice Coulson, as he then was, book Coulson on construction adjudication. And what's interesting about that is in his book, he had written that Section 104 applies, and I ask you to read these words carefully, to all contracts related to the carrying out of construction operations. And again, with the greatest respect, in relation to Section 104, which is what we are concerned with, that's not the wording used in the statute. So we see this has had quite a long gestation in terms of what the statute means. And my respectful submission, that isn't what it says in relation to Section 104. And then paragraph 22, Mr. Justice Aiken had said, in my judgment, there can be no doubt that a reference to a contract must mean a contract under English law, etc. Put another way, it must be primarily by reference to the contract entered into between the requisite parties that one determines whether the contract is one for the carrying out of construction operations. One then applies ordinary contractual interpretation principles. So he simply said, well, it means what it says, and that you therefore just apply the words of the contract. Paragraph 23b refuses to put any gloss on the words and says, well, you just apply those to the agreement and see if it fits within it. Paragraph 20...
So you're accepting paragraph 23, are you, as a correct statement?
Well, I say it doesn't really take it further, because I say there is a need for this court to give guidance on what the Act means, and I don't accept it because he quotes from Lord Justice Coulson's
paragraph
book.
23, talking about, do you dispute any of those three statements?
Well, 23b, one must be careful about adopting a syntactical analysis of the words when it's clear that Parliament intended a wide definition. I do take issue with that, because it isn't clear to me that Parliament did intend a wide definition. And I say that he has, higher up on the page, quotes from Lord Justice Coulson's book, which says that Section 104 covers agreements related to the carrying out of construction operations. If you actually look at the wording of the statute, there's nothing within that that suggests that's what was intended, or it has that wide meaning.
With this distinction between whether they're in the collateral warranty, whether they're undertaking a direct obligation for the carrying out of works, or they're just guaranteeing the performance of obligations to someone else, presumably, even if it was just a product guarantee, that would overcome the Murphy and Brentwood problem. Is there any other consequence, other than whether it falls within Section 104 or not, to that collateral warranty being drafted in a way that makes it clear that it is a direct obligation to carry out the work, rather than just a guarantee that you have complied or you will comply with your obligations to the employer to carry out the work? Does it have any...
You mean beyond Section 104 applying or not? I mean, I guess it would depend what the agreement said, what was added in, whether it gave you any right. Obviously, one of the things that is now odd is that there's a case called Hurley-Palmer-Flapp, which means if you're a third party and you get rights under a building contract, you cannot adjudicate. And that was drawn to Lord Justice Coulson's attention, and he said, well, that's just a different situation. So if you've got something akin to that, whereby although you're a third party to the contract, you're given rights in relation to it, you cannot adjudicate in relation to that.
Right, and we've ascertained that having those direct obligations doesn't entitle you as to be able to insist that the work was carried out as was originally agreed between the contractor and the employer. You're stuck with any variations that they may make, nor does it entitle you to change the nature of the work or the description of the work to be carried out. So I'm just wondering what the point of that direct obligation would be, unless it's to bring you within adjudication, which you would say, well, if you want to be within adjudication, just put in a clause that says disputes will be adjudicated.
Correct. Yes, I mean, I can't think off the top of my head what that would add. But certainly if you, as you say, you wouldn't need to do that, because you just say adjudication shall apply. So just to finish Parkwood, 24 and 24 is at page 874, paragraph 24. This is where he refers to counsel in that case, referring to the exclusion order in 1998, and counsel sought to cite that in support for his proposition that the word for in subsection 1 meant in relation to. And you will see at 26, 27 and 28 that submission is rejected. 26, Mr. Justice Aikenhead says, no, just because certain contracts are excluded, specifically excluded by Parliament in 1998, doesn't mean that everything else is included. So just for your note, that was any insurance contract, fidelity bonds, payment bonds, retention bonds, performance bonds. Mr. Justice Aikenhead says that the exclusion order was just clarificatory of the Principal Act, but he certainly was not willing to accept here the submission that for means in relation to. And then we see at paragraph 27, and paragraph 27D in particular, that this is where he deals with the word undertakes. And he does say that warrants, acknowledges, and undertakes are mutually complementary and have different meanings. A warranty often relates to a state of affairs, past or future. An acknowledgement usually seeks to confirm something. An undertaking often involves an obligation to do something. So certainly Mr. Justice Aikenhead read those words differently, and that it was only the third, the word undertake, which involved an obligation to do something. Warranting was simply the state of affairs, past or future, and acknowledgement seeking to confirm something.
You're not saying the word warranty can't amount to an undertaking to do something? It must depend on the context, doesn't it?
Yes, I mean, obviously, the word warranty or guarantee can have multiple meanings depending on what it's used. In this context, it doesn't. It
never does.
Well, in the context of this particular agreement, I'm not sure I can generalise beyond that in relation to the word warranty. I just wanted to show you very briefly, before I come on to the agreement itself, two articles from the construction industry in terms of the reaction, just to show that this has been a cause of concern for many. The first article is actually something that the respondents put in. It's at page 1016 of your bundle.
Justice Coulson's JA.
Yes, you're ahead of me.
Well, it was the respondents confessed and avoided.
Yes, I think we did notice when you read this online, it says he was a pupil barrister at Keating Chambers, which doesn't come out when it's printed out. But he was also Mr. Justice Coulson's JA at the time that this case was decided, and there have been some that said that it should be declared. But anyway, be that as it may, he obviously set out...
Not at the time that he wrote this article.
I don't know if he was or he wasn't at the time he wrote the article, to be honest.
I can say it wasn't. He was by then a pupil with us.
1016, the second paragraph, you will see he sets out clearly there, you don't just have to take my word for it. For many years, the industry assumed not. So they assumed that these warranties weren't covered. And I say that's extraordinary. And that should tell you something, that from 1996 till 2013, when Parkwood was decided, no one thought that these were subject to the Act. And then he sets out that the decision in Parkwood came as a surprise, and that it attracted criticism as well as extrajudicial endorsement. And you will see there's a footnote 5 there. That is actually Lord Justice Coulson again in his book. So most people were very critical of the decision, and it was then endorsed. And we can see, just to complete this history, because it is rather unusual, that somewhat unusually in the judgment, if you can just flick back to the judgment, and I'll come back to this article, at page 190 of your bundle, paragraph 42 of the judgment. There's a footnote there setting out, I'm aware that shortly after Part was decided, there were one or two articles in the Construction Law Journal expressing some surprise at the outcome. The judicial points made in those articles are all considered in this judgment. With respect, they're not, which is why I just want to show you a few of the concerns that have not been addressed. However, Parkwood was decided almost a decade ago, no subsequent decision. And then he says the construction industry, known for picking up on any TCC decision, can therefore be taken to have broadly accepted the result. This may help to explain why these arguments are not raised before the judge. As I say, that isn't accepted. It hasn't led to a rash of collateral warranties being put through adjudication. Then if we can go to something else which is at page 1088, please.
Did the adjudicator in this case say anything in his decision, remind me, as to surprise or lack of it at Parkwood, or this is an unusual case because I've never seen a collateral warranty being adjudicated on before? Make any comment?
I don't think so, I have to confess. There's not been a lot of attention paid to what the adjudicator decided.
Yeah, he gave a non-binding ruling, finding that the words were very similar to Parkwood. I can give you the reference.
Right, no, I know that, but he didn't make any comment expressing surprise or otherwise, because you just said there hasn't been a rash of collateral warranties being put through adjudication following Parkwood, but that's not based on anything that the adjudicator said in this case, so far as
No.
The reference is page 473 of the bundle, where he comments on Parkwood. On this case.
Yeah.
You were going to take us, was it to 1088?
Yes, 1088, if we could go there. I just want to show you some of the other concerns about the decision that have been expressed, just so you can see, because we've seen that that Lord Justice Coulson said those were dealt with in his judgment. With the greatest respect, I say they're not.
So what's the date of what we're looking at here?
So this is this is a practitioner text, Manual of Construction Agreements, so it's taken as of the date the bundles were produced, but it refers back to Parkwood, so it's a LexisNexis publication. It's a good question. I'll find out the exact
Obviously
date.
it's a loose leaf book.
It's a loose leaf, yes. So if you look back at 1087, the last issue was August 2023. And if we can then go, please, to 1100 of this bundle page. And there is a section in this headed Construction Contracts and Collateral Warranties. And it says this: early editions of this chapter discussed whether the statutory definition of construction contract could apply to a collateral warranty and expressed the view that such was plainly not the intention behind Part 2 of the Act, noting that most of the provisions of the Act could not apply to a collateral warranty and that none could apply given after the completion of the works. And then these words, which are important: the view advanced was that a collateral warranty is not an agreement to carry out construction operations, but at most a collateral promise to comply with an agreement to carry out construction operations, the essential element of employment being absent. And then at A148D at the bottom of the page.
Just could you give me that? Oh, yeah, sorry.
It says the decision in Parkwood was received with dismay by some commentators, one of whom has described it as simply wrong, substantially on the grounds canvassed in early editions, and on the ground that it mistakes a derivative obligation for a separate construction contract, which plainly, he said, it was not. And then a further reason to regret the decision in Parkwood, if it is correct, is that while a building contract that has been fully and finally agreed, whether before or after works are completed, is fully covered, a collateral warranty, perversely, is covered by and only by the adjudication provisions if executed before, but it is not or need not be covered by any part of the act if executed afterwards. And then obviously concerns that it raises a question as to the meaning of completion in this context. Obviously, simply in the Court of Appeal's decision, they dealt with the timing point in relation to Parkwood, but they replaced it, in my submission, with a different distinction about whether the terms of the warranty are just the product guarantee, or whether they say that there is some kind of continuing warranty, even if the works have been done in the past. Again, we would commend to this court to reinstate the words of the statute themselves and to find that those words mean what they say, that this is not a construction contract, but rather a collateral promise to comply with an agreement to carry out construction.
So that middle sentence, a collateral warranty perversely is covered by and only by the adjudication provisions if executed before the works are completed, but is not covered by any part of the act if executed afterwards. This case knocks that out, doesn't it? And says
it does, yeah.
Actually they're covered even if it's executed before the works, although the point that Lord Justice Stuart Smith said, which is that the collateral warranty can only come into effect on the day that it's executed, even if it relates to a past period. So this case goes beyond Parkwood by extending it further than that paragraph envisaged. Is that right?
Well, it changes it. So it gets rid of one timing distinction, but in my submission it introduces another one. So rather than this being based on the nature of the obligation, it becomes about whether you're warranting or making a promise only in relation to things that have been completed, or whether the wording of the collateral warranty says continuing in some ways, even if the works aren't actually continuing, even if that's a total fiction. And with the greatest of respect, that is a trap for the unwary. How are people completing these in the real world supposed to understand what does and doesn't fall within the Act? In my submission, it's much simpler to have the rule that we advocate for, which means that people know where they stand, they know they can include it if they want to, but they're not going to be caught by the Act inadvertently.
Just before you leave, could I ask you to look at 1101
Yes.
and the last four lines of paragraph A14, open brackets 8A, close brackets?
Yes.
And I take it that the collateral warranty in this case has no step-in rights.
Well, it does, but they obviously weren't exercised.
In the event of insolvency, there are step-in rights, aren't there?
Yes, correct. So a beneficiary exercising step-in rights would put himself in the same position. So it doesn't transform it simply by them being there, but obviously if you do exercise the step-in rights, you do put yourself into a direct contractual relationship. So we say that supports the position that we advocate for. It's this direct relationship point that is incredibly important. And
so you say the existence of the potential for step-in rights suggests that the parties thought there was something, that they would be in a different relationship if those step-in rights were exercised from the relationship they were in before the step-in rights were exercised.
They plainly will be in a different position because they'll step into the shoes of the employer. I mean, that's equivalent to having novation, you step into the shoes, and therefore all the rights both ways apply, and all the obligations.
And then you would be able to change the specification for the work.
Correct. Yes. And you would be able to adjudicate, but equally the contractor would be able to adjudicate against you. So if monies hadn't been paid, you would be subject to that, which is the whole point of adjudication, to have these obligations going both ways.
Are the stepping rights in this contract conditional on liquidation or insolvency or something of that kind?
I think they're just... Yes.
Insolvency as defined under the building contract.
Yes.
Right.
But as far as the adjudication going both ways in the contract as it is, if here the simply isn't paid by Sapphire or Topham, can they can't go against Abbey because Abbey has paid them the pound, but can they bring Abbey into the adjudication
No.
for their dispute?
No. No, I mean, this is one of the problems with making these sorts of obligations subject to adjudication as a compulsory position. Because the right to adjudicate, in my submission, only goes one way under the Abbey contract. It's a right in Abbey's favour, simply isn't going to adjudicate against Abbey under the collateral warranty. And then just to finish, this text then commented on simply at page, well, I would just take you to, it comments on it at length, but if we look at page 1111, A1480, and the authors there set out several paragraphs from the powerful dissenting judgment of Lord Justice Stuart Smith are noteworthy. And then we see what is referenced within this text is paragraphs 94 and then 100 down to 103. I'm obviously not going to read those out to you, but we would likewise commend them to you. We say this within the Court of Appeal judgment is the only passage which deals properly with the question of statutory interpretation and how the words in the statute should be applied.
And who has written this? Not Lord Justice Stuart Smith's JA.
Or Lord Justice Coulson.
No, indeed. But it's a shorthand way of showing you how this has been received in the sense that the voice coming in terms of how the act should be read as meaning in relation to has come from Lord Justice Coulson extrajudicially and then implemented in this decision. And other commentators have been extremely, have been less than enthusiastic and indeed said this goes down a wrong path. Obviously, it's now a question for your Lord and Ladyships to decide what should be the correct outcome. What I do just want to take you back to is the article from Lord Justice Coulson's JA at page 1021, where he pointed out some problems with the position that we're left in. So first, he adverted to the issue I've raised, which is now we have two...
Which page are you at?
Sorry, 1021. And there should be a heading going forward in bold. And he set out his view that he agreed with the majority in simply, which obviously we don't, but he then set out some problems or some anomalies that might result from it. So he said first, Despite both being contractual methods of providing third parties with certain rights vis-à-vis primary building contracts, the position of a beneficiary under a collateral warranty is now different to that of a third party given rights under the Contract Rights of Third Parties Act. And he refers to that decision in Hurley-Palmer Flat that I talked about. And that is something that Lord Justice Coulson refers to in his judgment. He doesn't give, in my submission, any principled reason for those being different. Second, timing, and then he sets out the problems which may arise. The date from which it's intended to take effect, whether it's prospective or retrospective, is critical. So where a warranty contains a promise which related to and regulated the ongoing carrying out of the construction operations, it's likely to fall within the Act. Where it doesn't, it is outside. And he sets out at the bottom, now more than ever, warrantors are going to look to draft collateral warranties in more innovative ways to avoid the construction contract characterisation. And this may lead to narrower methods of drafting. In my submission, that isn't a situation that we should be encouraging, or indeed that we should be in. Can I then just turn? I'm conscious of time.
If the adjudication process applies to a collateral warranty of this kind, it can't ever be used by the contractor to extract money out of the beneficiary. He's paid his pound, and that's the extent of his liability.
Yes.
It would only ever be used by the beneficiary to extract money out of the contractor.
Yes, correct.
So why I'm tempted to say, why do these articles, I suppose they are contemplating, are they draftsmen for contractors trying to make sure this doesn't happen?
Yes, absolutely.
When making their original building contracts, in case the collateral warranty regime ends up as being what matters, rather than their relationship with their employer.
Yes, correct.
But simply here, who's the warrantor, they entered into the warranty with Abbey because they had to, once Topham asked them to, pursuant to the obligation 7, whatever it was in the building contract, which says if we ask you, then you have to enter into that. So the terms of the, I mean, is this the common situation that the terms of the collateral warranty are not actually negotiated between the warrantor and the beneficiary, but between the contractor and the employer at the time when the building contract is concluded?
Well, it's probably quite difficult to generalise. It may depend on the contractor. I mean, in some ways, the smaller the contractor, the less bargaining power they have, the more likely they're likely to be dragged into this. They're likely to have adjudication awards against them, which they then have to go to court to challenge, without having the reciprocal right to bring their own adjudication against the beneficiary. It is a one-way position, this, and that is troubling. What people have said is it may also lead to people refusing to provide them, and obviously again that will depend on the bargaining position between the parties, but the people this is likely to affect most are the smaller contractors.
Yes, well, the contract that simply enters into with Topham may have been part of the, I don't know if this was tendered for, but may have been part of the tender documentation, and if you bid, then you have to enter into it.
Yeah.
But how does it work with subcontractors? Because in the building contract, I think there's also obligations for subcontractors to enter into warranties. Are they also then directly promising to undertake the subcontract work for the beneficiary of the warranty?
Well, again, it may mean that you have people being pulled into adjudication where that isn't really what's intended by this. I mean, as I say, no one's saying there can't be agreed to be a right to adjudication if that's felt sensible. But this obviously means that you fall into it and you cannot contract out of it. Can I just, conscious of the time, turn to look at the actual agreement in this case? Because I'm conscious we haven't yet looked at that. That's at page 430 of your bundles. And we see at 430, just from the title, this is a collateral agreement, but in some ways it's a one-way agreement, and it says in favour of a beneficiary. And then if we turn over to page 431, we see obviously Simply is the contractor in this agreement, Abbey is the beneficiary, Topan is the developer. And then in the recitals, obviously setting out there is a contract between the developer and the contractor. Beneficiary is a leasehold interest. Contractors agreed to enter into this agreement with the beneficiary. Now, the definition of contract is important. It says that it's a contract in the JCT form, and then these words, under which the contractor is to carry out the works and the design of the works. So the wording of this agreement made very, very clear that it wasn't intended to replace in any way those performance obligations which remained owed under the building contract. And then the works, I would also draw your attention to the definition of those, the construction of the development of the site as more particularly described in the contract. So again, it's referable back to the contract. Then over the page 432, we have obviously the consideration, the payment of the pound. And then at 4.1, we have the words, the contractor warrants that. And we say everything that follows is part of this warranty. So again, the words are important. It's a warranty to carry out and complete the works. And when you track that back through the definition of the works, that means performing the contract, the main contract. And then B, carrying out and completing the works. Again, the same point.
You said that 4.1a...
Sorry, I misread it. I misspoke. You're correct. 4.1a is will diligently perform the obligations.
Do you accept that includes completion of the work?
Well, all 4.1a does is says that he promises to perform the obligations under the contract, so promising to perform the obligations owed to the developer.
Which would include completion of the works.
Well, B refers to carrying out and completing the work.
No, I'm asking whether A includes that.
Well, yes, because the obligation under the building contract includes an obligation to complete.
Exactly.
So it includes all of those obligations owed under the building contract to someone else. Yes. And then 4.2, I think, is relied on to say that there are obligations owed under this agreement. I can respond to this in reply. We don't understand that obligation because or we don't understand how that assists the respondent, because all it says is that insofar as you perform your obligations under the contract, then this is to deal with the date that it's effective. So this is giving retrospective effect. And the use of that word obligations, we say, doesn't transform this.
But this is not,
else.
this is referring to retrospective effect of the building contract.
Yes.
It's not referring to retrospective effect of this collateral warranty. What this seems to me to be dealing with is that the building works started on the site before the building contract was concluded, because it's talking about performing the obligations under the contract before the date of the contract being the building contract, not this contract.
Well, I think what it's saying is if the under this agreement, if those works under the contract have already been performed, they take effect in all respects as if the contract had been dated prior to the performance.
Yeah, but the contract with a capital C, as you showed us, is the building contract,
yes, it is,
not this contract.
Yeah.
So that's saying that the building contract takes effect retrospectively. It doesn't seem to me at the moment to be saying anything particular about whether this contract takes effect retrospectively, because this is this is the agreement, this isn't the contract with a capital C.
Yeah. And then we have 4.3, no greater duties. So that's the point that you can't have greater duties than owed under the contract. And then 4.5, there's a further warranty that unless required by the contract, it won't use materials in the works. And the works, again, is a defined term going back to the building contract. So my short point is everything in this is referable to the building contract. There's no separate obligation in any sense that is undertaken or taken on by simply.
What's the effect of the last line and a half of 4.3? Save that, this agreement shall continue in force or transact notwithstanding the termination of the contract for any reason.
Well,
if the contract went off by an accepted repudiation,
yes,
you presumably draw a line in the sand so far as obligations
post.
with respect to which the beneficiary could sue is concerned.
Yes.
But this would still be a live way of achieving a recovery.
Correct. I think it's intended.
It's not intended to mean, as I understand it, that the contract should be deemed to have continued in effect.
No. No, it's not. It's simply to clarify that if the building contract falls away, and in a sense, my lord, that's important. It shows that they thought there was a risk. The drafters of this thought that this agreement was entirely parasitic upon the main contract. There's no separate carrying out obligation being taken on under this agreement. And that's why you have to have that provision for the sake of clarity that if the main contract falls away, the beneficiary will still have the rights up to that point.
But how does that work if the contract falls away because of a breach of it, a repudiatory breach by Topan? It can't be, as my lord says, that Abbey can insist on simply completing the works when they're not going to pay for it. But in an adjudication, if simply has a claim against Topan, which they could set off against any sums that Topan was claiming against them, does that set off also work against Abbey?
No.
Right.
I don't think it would. Well, certainly the payment provisions can't be operated in the same way. I'm just trying to think through. I think this is aimed at simply saying, look, if the building contract falls away, we still have the rights that were given to us by this agreement. Those rights can't go beyond the building contract. It doesn't mean that the building contract continues, but it's to deal with somebody saying, well, now the building contract's fallen away, you don't have any rights at all. Yeah. So say the contractor had done something before that date that had resulted in a defect that had to be fixed by the lessee or would cause the lessee loss, that past claim would still be in existence. I think that's all this is intended to cover. And then, obviously, there's a requirement for insurance at paragraph 5, copyright at paragraph 6. You will see these are all performative obligations in contrast to 4, which is completely parasitic. And then step-in is at 7. And that is obviously if the developer is insolvent and the beneficiary gives notice. That it is only in that situation that the beneficiary can direct and require continuation of the obligations under the contract. And that is why at 7.6, the developer was a party to this agreement, so that it could confirm that it had consented to those step-in rights.
And that is then to the exclusion of the developer?
Yes, correct. So in a sense, it's obviously a step-in, but it's a form of novation. Yes. In the event of insolvency. So we say that looking at this, it's plainly not something that was intended to be covered by going back to 501.
Just before, under assignment, clause 8, the benefit of the agreement could be assigned by Abbey without the consent of simply.
Yes.
And then I suppose the question would be, well, does that mean that simply now owes those direct obligations to another that Abbey has chosen?
Yes, I mean, I think that's the effect of that provision. The obligations set out in this, obviously, the contractual obligations remain at all times owed to the employer, or Topan as the developer to whom the contract was novated. But there are obviously separate obligations that simply undertakes in this agreement. But those are promises to pay damages if there's a breach of the building contract. They are not, looking back at 501, it is not an agreement for the carrying out of construction operations. Those obligations only exist under the building contract, and nothing within this agreement changes that. I'm conscious of time. Obviously, if there are other things that I can usefully deal with at this stage, I'm happy to. I think on the sheet it was indicated that it seemed best to break for lunch now rather than interrupting. That was certainly the sheet that we were handed.
I don't think so. I think
okay.
Your time runs out now.
Yes.
And we get half an hour of your opponent before lunch.
Can I just ask you this? You haven't taken us to the obligation under the building contract for requiring simply to enter into this warranty.
Yes.
Is that because there's nothing in that helps us decide which side of the line, assuming there is a line, this warranty
Correct.
lies on.
It's obviously part of the background in terms of how the warranty came to be entered into, but I don't say that the question for you is this collateral warranty a construction contract within the meaning of section 104? That's the question.
Yes.
And the fact that there was an obligation to enter it within the building contract, in my submission, doesn't affect that question.
And nor is it affected, as I understand it, by the fact that this was a bespoke warranty, slightly different maybe from the one that was appended to the standard form contract, and they took the trouble of deleting that and putting this one in, but we don't get any assistance from that.
No, I don't think you do, and you will have seen that Lord Justice Coulson says actually this wording is relatively standard. But in my submission, this appeal shouldn't turn on those points. The important point is this an agreement for the carrying out of construction operations within the meaning of the Act?
Yes.
And we say it plainly isn't.
Just before, can I just ask one small question?
Yes.
If 4.1 had said the contractor undertakes that, and then continues as it is, would that make a difference to your argument, or would your argument be the same?
Well, I think we go back to the same point of debate that we were having in terms of whether that's the thing that makes the difference. I suppose I would try and run it both ways, which is to say that if you take the view that undertakes, certainly the view that was taken by Mr. Justice Aikenhead and Lord Justice Stuart Smith was the word undertakes did mean that was a direct obligation. But it has to be a direct obligation, which could then be enforced by the beneficiary. And certainly the way this agreement is set up, everything is conditional on performance of the building contract, with that duty being owed to somebody else, and this simply being a right to recover damages if those obligations owed to somebody else are not performed. So it would have to be worded in such a way that you were directly performing the building works or the construction works for the beneficiary, but we're very far from that on the facts of this case.
Yeah. Thank you. Mr. Nissen, I can see that you may have been told we were going to take an early lunch. We weren't told. So if you don't mind, carry, if it would upset either your preparation or your digestion, carry on.
My catering arrangements will remain as they were. Thank you very much. You'll have gathered that this is a case in two parts. There's the question of construction of the Act and the meaning of the words for the carrying out of construction operations, and there's the proper interpretation of the ACW. I'm going to focus rather more than my learned friend on the proper construction of the agreement, because we respectfully submit that's what he is about, and there really is ought to be nothing between us in respect of the legislation. When we get to the proper construction of the provisions, my learned junior, as he once was, Mr. Owen, KC, is going to address you on a couple of provisions within the building contract, which specifically themselves refer to the beneficiary, because we say that is material to the consideration of what arises in this case. So I'm going to just touch...
by all means, choose when that will be most convenient to do.
Thank you very much. Our primary position is that none of the points about the meaning of the word for arise in this case. It's common ground, at least it was on the documents, that a collateral warranty can be a construction contract. See Simply's written case at paragraph 59. Where it says a collateral warranty will be an agreement for the carrying out if it's an agreement by which the contractor undertakes a direct contractual obligation to the beneficiary to carry out the construction operations in the building contract. And and then it says elsewhere, where the collateral warranty is an agreement by which the contractor undertakes a direct contractual obligation to the beneficiary to carry out the construction operations. And we clarified in our case that, subject to the caveat as to what they meant by the word direct, we were not in disagreement with that. The arguments that have been wide-ranging in the written case and yet further wide-ranging today have arisen, we respectfully submit, from a misconception as to how the issues arose in the Court of Appeal. In the Court of Appeal, the issue was a full-on attack on the concept that a collateral warranty could ever be a construction contract. The definition of issue 1 in the Court of Appeal, as identified by each of the members, is at page 187, at paragraph 26. And you will see there, issue 1 is, can a collateral warranty ever be a construction contract as defined? Issue 2 is the question of construction, and issue 3 it did the date of execution, which was the basis of the learned judge at first instance's decision, make a difference. So, important to note that paragraph 26A was a conceptual question about whether a collateral warranty can ever be a construction contract. And it was not a proposition that a collateral warranty could never be a construction contract. It was can a collateral warranty ever be? And the question of how broad or how narrow or on what basis you construe the word for was all focused on that conceptual question. They have therefore, my learned friend and the appellants, have sought to weave some dialogue, narrative of issues between the respective judges of the Court of Appeal on that question, but on the question on which all the court were agreed is that Parkwood was correctly decided. And Parkwood is undeniably a collateral warranty. And the grounds of appeal in this case are that Parkwood was correctly decided. So it follows, if Parkwood, and Lord Justice Smith says he is content to agree that Parkwood was correctly decided. And so the issue in this case is this collateral warranty, the ACW in this case, on the side of the line that constitutes, falls within section 104.1. That is the critical point, which depends on the terms of the contract. And arguments in the abstract about the breadth and width and all the rest of it that one saw in the Court of Appeal were on a question which is, in my submission, not now before this court, which is the answer to question 1. Because that isn't the point that now arises.
It wasn't appealed, was it, at that ground of decision, was it?
Correct. What's happened in this case, and they are frank about it, is that they have, excuse the colloquialism, pitched their wagon to Lord Justice Stuart Smith's judgment for the purposes of this court, which was, they recognised, not on all fours, or indeed I would say not on any legs, the same as was maintained in the Court of Appeal. It's a different case which draws a different distinction from is a collateral warranty a construction contract, whatever its terms, whatever. The distinction that Lord Justice Stuart Smith made in his dissenting judgment was a difference between two different types of collateral warranty. So it wasn't about collateral warranties as a breed. His distinction, which was newly fashioned in his dissenting judgment, was there was a difference between two different types of collateral warranty. One essentially akin to a product warranty. This television has been satisfactorily built, or your car is marvellous. Essentially backward facing, the product has been delivered. On the one hand, and what we would respectfully call a performative collateral warranty, which envisages the carrying out and execution of works to achieve a specified standard. And if it is a performative collateral warranty, which depends on its terms, then it is perfectly capable, in principle, of being an agreement for the carrying out of construction operations under Section 104. If, on the other hand, it falls into on the other side of the line and is a retrospective promise, in effect, retrospectively, that which has been done is in accordance with a set of standards and terms, then the remedy in respect of that is limited to damages to the extent you didn't get that which was warranted. If, on the other hand, it is a performative one, then it gives rise to additional rights and remedies and is in the nature of an obligation. In other words, it's not merely a promise that a certain state of affairs exists, but it gives rise to obligations. And that is the distinction which falls to be made, and that is indeed the.
What if it's a promise that a certain state of affairs will be brought into existence?
Well, one needs to look at the language in any case, but if it would be brought into existence is a future promise which can only be achieved by the performance of certain obligations.
So you would say that would be sufficiently performative to fall within Section 104?
Yes. It's in light of that we have said in our written case, this isn't a case about Section 104 at all. Literally it is, but it's not a case about the breadth of Section 104, it's a case about the terms of the ACW. And so I will address some of the points my learned friend made about what a traditional building contract looks like and so on at the end. But unless the court wants me to do otherwise, I prefer to focus on the terms of the warranty.
Lord Justice Stuart Smith did discuss that you could have what one might call a warranty in the narrow form relating to future performance. And so at some point I'd like you to address what he says about that.
Yes. Certainly. So I'm going to cover.
Do you accept that there is a difference between for and in relation to, and that insofar as Lord Justice Coulson substituted in relation to or for that was wrong? I think our submission is they mean essentially the same. You don't. One sees the crossover in relation to Section 104.5 that in relation to is defined. I'll take the precise words round by the second sentence.
I mean, you can't really say that for carrying out construction operations and in relation to carrying out construction operations means the same thing. I mean, the in relation to has a much more indirect connection. I mean, why wouldn't a loan agreement made specifically for the purpose of funding the contractor's obligations be an agreement in relation to the carrying out of construction operations?
Well, the reason I took you intended to take you to Section 104.5 is, as my Lord Richards has identified, the second sentence is. Yes,
but all that is doing is defining what relates to means in the first sentence. It's not substituting relates to for. in subsection 1.
It's an agreement relates to if it makes provision of any kind, and provision of any kind takes you back to 4.
Quite. So it doesn't substitute in relation to for the word for in 1.
I mean, I should say it's not part of my case that there's anything, our case, that there's anything to be gained from focus on the words in relation to as themselves broadening the word for. We don't have any difficulty.
So in relation to would still require that performative element as that term is used in this legislation.
Yes, because you still come back to 4.
Yes.
The point is, in respect of the word for, both Lord Justice Coulson and Lord Justice Peter Jackson construed this agreement as being one that met what we would say is the requisite test, that involved a direct obligation being owed by simply to Abbey. So in the context in which this appeal is now being heard, the breadth argument is no longer relevant because it met the test that was arose. The discussion about in relation to was all under the banner of can a collateral warranty ever be a construction contract? So the answer is it's not part of our case that anything particular turns on it. We simply focus on the nature of the obligation that's and whether it's performative. So far as the ACW is concerned,
just to make this clear, so the essence of your quarrel with Miss Day is that you say it doesn't matter that the promise to the beneficiary to complete the works is expressed to be a promise to do that which is in the building contract owed to somebody else to complete the works. You say it doesn't really matter to whom it doesn't matter that the promise is to do something which you've contracted to do to somebody else.
No, not if you're repeating it to me.
Repetition to you is enough.
Yes. Yeah. The fact that the scope of the obligation is defined by reference to what appears in another document does not deprive it of the status of a performative obligation owed to me.
And even though you have no ability to alter that description, the nature of the works or the description of the works is entirely in the hands of other people and not in your hands.
That's right, although in commercial terms you would expect the beneficiary to be in discussion with the developer about proposed changes that the developer might make. That is understandable.
But that's as between the developer. There's nothing in this contract about that.
Absolutely. No, we are subservient to the operation of the building contract in terms of its scope. And that's why there's the provision that says that they don't owe any wider obligations.
Why does it say wider rather than different?
I anticipate it's to make clear that they're not taking on anything broader. Well, it's just a different word from wider. I don't know. I'm afraid. I wanted to cover, if I might just identify the headings of the topics that I propose to address. First is what is a warranty? Second, to look at the pro forma JCT collateral warranty terms. Third, to look at the terms of the building contract. Fourth, the terms of this ACW. Fifth, to look at, insofar as it is a consideration, the prospective and retrospective nature of the obligations and the date of execution. 6, does it matter that there was no express adjudication provision? 7, a comparison with Parkwood. and 8, the availability of injunctions / specific performance. So firstly, what is a warranty? My Lord Briggs, I suspect, may have already identified this, or at least our case as to it. A warranty is simply a promise which is intended to be of binding effect. That's paragraph 62 of our written case. And we cite Mr. Justice Devlin, as he then was in Compagnia Naviera. Every term in a contract is at heart a warranty. We don't respectfully accept that the point of entry is, as described by Lord Justice Stuart Smith, that it is to be assumed that it is normally a promise about a fact, circumstance, or outcome. His approach is that's what you start off with when you think about a warranty. And we've referred in our written case to passages from Chitty and Anson, which describe the character of a warranty, and it is simply a promise. That is, in a sense, the beginning and the end of it.
So is collateral the word that we should be focusing on?
Not particularly. I mean, the document is, of course, a collateral warranty, but the focus within that, the reason I'm identifying warranty is because that is the word that is used in the agreement. I think the Court of Appeal will all agree that the label of the document itself, or as a collateral warranty, was not in any sense a guide. What one's looking at is the word warranty as it's used, or warrant, should I say, as it's used in the terms of the agreement. And in particular,
does it say collateral warranty in the body of the agreement?
It does also describe itself as that in clause 9.
It does.
Yes, it does.
We submit that the focus is not on the word warranty, but on the subject matter of that which has been warranted.
I mean, it is fair to say, isn't it, that warrants used in the sense of promise is probably not that common nowadays. It's not really current legal usage, is it?
There's often a tendency, I think, in certain industries, and maybe insurance is one, where or bonds, I think, is another, where there's a reluctance to innovate with wording because things have a certain established meaning, even if they may look a little.
These collateral warranties are not that old, are they? They came about as a result of Murphy.
Yes, they did.
So we're not going back into the 18th century and Lord Mansfield.
No. Not.
But it's just a slightly odd word to use, I would have thought, in current times.
Well, nonetheless, I would respectfully submit that they nonetheless have regard to what the established meaning of warranty is, which is it's a conventional promise.
Right.
The definition which Lord Justice Stuart Smith identified in the Oscar Chess case itself confirms that a warranty is a binding promise. On the facts of that case, it happened to be one which Lord Justice Stuart Smith would say was a particular type of warranty, but it doesn't answer the question whether it's performative or a warrant as to circumstance, fact, or outcome. Insofar as Lord Justice Stuart Smith suggests that a warranty is a promise or fact or circumstance rather than an obligation to do something in the sense that it has a performative element, we would respectfully disagree that, and our position and our submission is that all warranties are capable, are simply promises. One then has to look at what it is that's been warranted. Could I then take you, that's all I wanted to say on that topic. Could I then look at, please, the pro forma JCT terms? And I do that because simplest written case was that the ACW in this case was based on the JCT form for purchasers and tenants, which we respectfully don't accept. And as I think Lady Rose has already pointed out, the warrant in this case was bespoke. But could we look, please, at the page 800 well, firstly, to look at the introduction to this, which is Mr. Justice Aikenhead in Parkwood at page 874. He makes this point. He says there are...
Which paragraph, sorry?
It is... apologies, hang on. Yes, right at the bottom right, 27A.
Thank you.
There have been no suggestion in that the form of collateral warranty used was in a particular standard form. Indeed, there are only a few standard forms for collateral warranties. In Mr. Walton's article, to which you have already been taken, at page 1021, he says, whilst, there's the bottom paragraph, whilst most collateral warranties are drafted in similar terms or follow a familiar form, not all collateral warranties are the same. That's the background in which I wanted to take you, please, to the different warranties. Could I start, please, with the funder warranty, which is at page, the introductory, the front page is at page 1031. Where you will find the front page for CWA F for funder, contractor collateral warranty for a funder 2011, and then at 1038.
So this is a pro forma
Used by the JCT.
Right, but it wasn't actually used in this case.
Absolutely right. But I think, well, if I take you to them, you'll see where I'm going with this. So 1038 is that which is warranted to the funder. And a funder, of course, has a particular interest in the completion of the work to, in accordance with the building contract, he's investing his money in it. And one sees at clause 1, the contractor warrants that he has complied and will continue to comply with the building contract. So we would invite you to note the use of the word warrants there in clause 1, nothing more than that. And at clause 1.3, that it refers here to the obligations of the contractor under clause 1. And this is a point to which I hope to return, which is the use of the word obligations is important here because it characterises the performative element of that which is being undertaken rather than merely a warranty as to a fact, circumstance or outcome. And we'll come to it, but my Lady Rose was looking at clause 4.2, I think it was, and said, well, this was about the dates of the building contract and so on. The point we were drawing from 4.2 was that it contained the word obligations under this agreement. So it assumed a performative element in that which is being
Why should the obligation be performative? I mean, you can have an obligation that you've promised something that's happened in the past to be true, and therefore, if it turns out not to be true, you have an obligation to pay compensation.
Well, we would respectfully submit that the way a warranty of fact, circumstance or outcome was identified by Lord Justice Smith was that it would simply result in a liability for damages for the warranty not being true.
There's still an obligation to pay damages. I mean, most people would cough up under a contractual obligation without waiting to be taken to court.
Yes. Well, we would submit nonetheless that there's something to be taken from the word obligations, plural, that it is intended to refer to the performative element of that which is undertaken, so that is the and the guidance notes at 1053 to this form explain at page 1053 under clause 1, this confirms the contractor owes the same obligation to the funder as he owes to the employer, subject to clauses 1 and 1.2, and then a little further down the notes, the guidance by clause 1.2 and subject to clause 1.1, the funder is intended to be in a similar position to the employer in terms of enforcing rights under the building contract, in that the contractor may raise against the funder the same defences. So that's why we say the flavour of it is.
But we don't have that in our contract.
We don't have that, but as you will see, I'm drawing a distinction between the funder type agreement and what I'm now going to come to, which is the collateral warranty for a purchaser or a tenant, which is at page 1057.
But would you say that this contract is a contract falling within section 104?
Yes, I would.
I think we'll reserve that until 2 o'clock.
Thank you very much.